So last week, we looked at surrogacy arrangements and personal services contracts in general, some unique family issues related to having children and the like there. And this week, in Section 10, first class, we turn to other issues with respect to family law. And it's an area that there's always a lot of significant issues. And like the last one, I think every case that we handle has a certain emotional aspect to it, the surrogacy cases, these cases, the family law issues always seem to have not just a fair amount of legal entanglements, but a lot of emotional baggage that comes with it as well. So you've got to be mindful of that if that's the type of work you're going to do, and be patient, but also recognize that it is an area where there's a lot of business for us because people are fighting about things that are important to them on a personal level, but also on a financial level as well. So it's an area where there's an awful lot of legal work to be done. Before we get to those cases for this week, I want to mention Rules 5 and 6 to you because they are really, I think, underappreciated rules, but they become important in the practice of law, and the things here that you should be knowledgeable about and know that you need to look there at times because it'll have the solution to some relatively pressing problems at times. First of all, Rule 5 just simply is the rule that talks about how papers and pleadings are ultimately served. And once we have actually filed the complaint and there is an answer on file, usually that answer would be filed by an attorney, from that point forward then whatever papers you file would be filed upon the attorney as the individual's representative. If there is no appearance or if there is no answer filed by an attorney, then you would serve the individual who was named with whatever motion papers or discovery requests and the like you have. But if they're represented by counsel, then obviously Rule 5 talks about then the manner in which that counsel needs to be served. And a text message isn't likely going to do it if you look at the rule. And there's a lot of papers now that are filed electronically. In federal court, when we file a document, virtually simultaneous with the filing, it is served upon everyone who has an appearance in on the case. So more and more courts are requiring electronic filing and electronic service of other individuals. And the good news and the bad news about that is that you get it virtually immediately, but that's the bad news as well, because now when we talk about time to respond, it's not a question of when you get your mail that day. The likelihood is you've already started the clock running because you have those papers in hand. But the good news is that you can start to work on it and figure out how many days you have to be able to respond or required to respond to it and the like. But you do want to start to get familiar with the electronic filing and have some level of reasonable comfort in that regard. Because many state courts outside of Massachusetts require papers to be filed electronically, and virtually every federal court now, the papers are filed electronically. That also means, though, is that all those databases generally you're able to examine by going online. I was looking at the papers filed in the Kraft case before I came up. Before that would have been quite a chore to try and figure out what was filed in Florida recently and what the motions are and what the memorandums say. Right now, anyone can find virtually any of these papers simply by knowing what court they're in. If they're in fact filed electronically, they're very, very easy to get access to. And so more courts are going that route, making you do really all the work that used to have to be done by a number of people in the clerk's office, because virtually you're docketing everything yourself at the time you file it. So you have to have some primitive computer skills because otherwise your papers are not gonna be received, and if they're not filed properly, then that's on you, not on the court. The other rule is Rule 6. So Rule 5 talks about how you're going to serve the papers once the case is moving forward. It's not the summons under Rule 4. 5 talks about as we go forward, depending on what parties have answered, what parties aren't, how you serve additional papers and pleadings in that case. Rule 6 is the rule that talks about how much time you generally will have to respond to pleadings and memos supporting motions and the like that are filed in the case. And the reason Rule 6 becomes important is that there will be times where you're served papers and you're trying to figure out how many days exactly I have to respond. And it may make the difference of whether you're working that weekend or not, as to when you start to figure out how to compute the time. Do the weekend days count? What happens if there's a holiday? What happens if it ends on a holiday? And Rule 6 deals with all of those actual issues about the computation of time. What do you do on the last day? How does legal holiday work? And so, sometimes when you look at this, or you get your motions and say, oh, I have a short time to reply, when you actually work through the days, depending on what type of motion it is, sometimes you find out that even though it's supposed to be 7, I could have, between the 2 weekend periods and the like, I could have a couple of weeks almost to respond. The reason it becomes obviously important is that just to manage your own schedule and to make sure you meet the deadline. So you want to take a look at Rule 6 at some point to start to think about, okay, how do I compute the time in which the drop dead date to reply is, and to make sure that my argument is heard. Because there are a lot of courts now, especially with the electronic filing, that some of this is done not by any person in the office, but simply by the clock on the computer. When it says 10 days has elapsed and there's no reply, and 10 days is all you get, that thing sometime that night could spit out that the motion is automatically allowed without any clerk or judge really seeing it, simply because that's the way the computer process has been set. Without opposition, motions are generally going to be allowed. And so you want to be careful to make sure you compute the time properly, and Rule 6 is how you would take a look at figuring out exactly how much time you have to reply. And listen, if you compute it and you look at it, 2 things in that regard. If you compute it and look at it and say, there's no way I can get affidavits signed, clients out of the country, I've got a trial that's going to take 3 or 4 days in the middle, I need to get an extension. Well, don't wait till the time has lapsed. Call counsel, ask for the professional courtesy of a modest extension. The likelihood is if you ask for a modest extension, you'll get it. You ask me for 90 days to reply to a motion that should have been done in 14 days, you're not going to get that. But let's assume you still legitimately feel you need that time. I still think it's a mistake, okay? 90 is not a reasonable professional extension unless your client is in Afghanistan fighting a war and is unreachable for that type of time. I mean, it better be an extraordinary explanation. But the fact is that if you don't wait till time elapses and the other side won't agree, then go in beforehand asking for the extension. And again, a reasonable extension is likely to be granted. A couple weeks wouldn't be a problem, 30 days isn't a problem. But be careful that you don't overreach, because then the court is going to simply say, no, you're not getting an extension at all, you've got to comply with the deadlines. But especially don't wait till the time has lapsed and then ask to be filing stuff late. It's unprofessional, it's not likely to be treated well by the court. And the fact is, if you're constantly not meeting deadlines, then that's the reputation you'll have, and you're going to have problems with getting the court to listen to your latest excuse at some point. It's just not the appropriate way to work. What you have to recognize, and that's why I'm pointing out Rule 6, there will be times when you compute it that, yeah, damn, I didn't plan on it, but I'm working Saturday and Sunday, I've got to make this deadline, I've got to get it done. that's the nature of our business at times. The deadlines become crucial in order to satisfy your obligations to the client and to the court, and you just better be prepared to meet them, even if it means lots of long nights and sacrifices. And to the extent you truly need an extension, and there are a lot of times where lawyers will call and ask for a modest extension, and as a general matter, it is a professional courtesy. But at the same point, we have to be mindful that there's some lawyers will do anything to delay the ultimate resolution of the case. And so constantly postponing and missing deadlines and stuff, it's a tactic at times. And so while it may sound discourteous to say, I can give you 30 days, but I'm not going to give you any more than that oftentimes that's the likelihood. And by the way, if I don't give you 30, as a practical matter, I know the court will give you 30 in almost all of these instances. So I don't want to look like a jerk when we go before the court and say I wouldn't give you anything. So you ought to think about that as well. It's one thing to say, well, no, we're going flat out, scorched earth here, we're going. If the other side goes in with a request for a modest extension, the court's going to give it to them, and you look like a jerk for wasting the court's time. On the other hand, if you're the other side is constantly delaying the matter, and I give you a modest extension, but that's still not good enough, well, then let's go in and argue to the court as to what our problems are, because I'm willing to give you, what I've done in the past, I will extend the deadline for this and give you additional couple weeks or a month even, but I'm not putting off the trial of the case. Because to the extent you start bumping that out, you absolutely are bumping out the ultimate likely resolution of the case. So it's one thing to move while we're in sequence about saying, okay, take an extra couple of weeks to get me those documents. Take 30 days to get me the documents. And we can extend the discovery time period for an additional 30 or 60 days. But I'm not moving the trial date. So that means we have to compress some stuff on the back end. If that's what as long as it doesn't, as I see, prejudice me or my client, we can accommodate you. But if the idea is that you want to bump everything out too far, and I think it's more done for dilatory reasons, which are illegitimate, than actual problems reaching the client or the people or finding the material that you need or personal crisis, right? I've got a sick child, I've got a sick partner, I've got a parent to bury. Those types of things you just have to accommodate. Life, so don't be the jerk that says, no, I don't care that your mother died, get the papers into me. Because you don't want someone else going into court saying, my mother's dead, I have to bury her, I lost this week, and he won't even give me 4 extra days to file my responses to his discovery request. You're going to look horrible there, and you won't be well received, and the court is likely going to hurt you down the road for wasting such time and being so discourteous under such circumstances. And so be reasonable, be professional, because there'll be times where you might need the same extension, and that's the thing to think about. If you're going to sort of draw the line and say, no, we're going flat out here, I'm not going to give you any, there'll come a time where you're going to have to make the same call and say, listen, I need an additional week or two. And it might be, it could well be in that very case, or it'll certainly be with some other case down the road. You want to be professional and courteous, but you also want to be mindful that you've got to be careful that you not prejudicing your client's rights by delaying the resolution of the case in its entirety. There'll be some slippage in every case, but you want to be careful that it's not a lot, such that you find yourself having lost 6 months to a year simply because the other side was uncooperative. And there will be many times where they'll be uncooperative, but that means you then have to push back, and sometimes you legitimately do have to be kind of a jerk. But that's the nature of the litigation as well at times. But Rule 6 will allow you to be able to compute when it is you actually have to, at the end of the day, make sure those papers are in. There's a lot of lawyers, they still do it. They file stuff Friday at 3 o'clock, or 4 o'clock, or 5 o'clock. So now you've got the package of materials, and the question oftentimes is, am I working this weekend? Do I have at least 10 days so that I can do this next week, or is this due sometime next week? Because, and I think it's intended as such in many cases, is that if they're going to try and count, if they can, Saturday, Sunday, the next Saturday and Sunday. If you think about that, there's four days that aren't typical work days, certainly not full work days for most people. Out of 10 days, 4 of them would have been days you have off. So does that mean you won't do as professional a job in responding? Was it done simply for that purpose, or is that when I just got the work done and want it to be done at the end of the week? There's a whole bunch of potential reasons. It's just odd how some attorneys use Friday at 4 as the time when they've decided to crank it up a notch, and so Rule 6 comes into play as to what's the time period I have to respond to this motion. And so you want to take a look at Rule 6 and really think about Rule 6 as to how it works. So special relief for families we're on. So all of these deal with family law issues and the like, and they have questions with respect to exactly how this all works. The first one is Burke versus Revo, which is, I think, an interesting case. Yeah. Sure, go ahead.
Are there any rules governing computer glitches since we're moving to this?
What do you mean computer glitches?
Well, I remember
Dog ate my homework?
No, I'm talking about, like, Pacer, for example.
Oh.
In the past, I've actually a little familiar with the Pacer system. I remember I filed one thing and then it just kind of went off into the black space. That was years ago, when Pacer was really coming out.
But it still should be able to show you or give you a receipt for having actually filed it, right? Because, and that's the thing.
At that time, it didn't. I think they fixed it.
Well, but it's a fair point, right? I mean, I file it, it sure looks like it's filed, it spits it back. Again, we have to practice law a little defensively. You need to somehow try to get a receipt and ensure that it did what it was supposed to do. Because it still happens, even though Pacer is the system in federal court for filing and obtaining papers in every federal court across the United States. You create an account, give them a credit card, they charge you. There's actually some, I think there was, and it may still be pending, a class action, because the argument is when the federal government set up Pacer, it was supposed to only be self-sustaining. So it was supposed to charge you whatever the cost to administer the program was. And instead, what they're charging, it's a lot. It may be like 20 cents a page. It's all done electronically. It's my paper. It's my ink. And if I want to access it, I'm charged, and it's a fair amount, and they're making a big profit. So there's a class action that says whoever is enrolled in the PACER program, whatever they've been procuring online, they're overpaying. But Ray's talking about the actual filing of the papers themselves. And with any computer system, and it's not all, the state court systems all have their own, that obviously technical glitches can come up. The fact is we think we filed it, it sure looks like it's filed, but then I go there and it's nowhere to be found. We filed something down in Connecticut. I'm trying to remember what we did. I think we were trying to wait till the end of the day to make sure whether the information had been updated, because we were expecting them to do something. They didn't do it, so we filed it. And every other document that was filed at 5 o'clock or 6 o'clock or 7 o'clock all said filed on the date it was filed. We filed something at 5 o'clock and it said it kicked it over to the next day, which we didn't want to kick it over to the next day because we wanted this thing to move faster as well. And so I said to Amy, I said, call them and see, because that just shouldn't be right. We should get the benefit of the day before. And it was a deadline date, sort of. I'm trying to remember what it was, but it wasn't a big deal. But I did want the benefit of the day before. No one could tell us why this one wasn't recording on the day it should. No one could change it either. That's the other thing. Oh no, the computer says that's when, if the computer says it was done the next day, it was done the next day. No, the computer actually shows it, at least on our receipt, filed as of 5 o'clock on the day before, but records it on the docket the next day, even though that's not generally the practice. So that, you're right, that's the problem. Now here, even in that case, we couldn't get it fixed, even though we had the proof that it was filed on the day before. And at the end of the day, it wasn't a big consequence. It was just I wanted to get the benefit of it. But the fact is, you do have to think about that type of problems, especially if it's a deadline that you have to make that day, such that you could be defaulted or you could be found not to have complied with the court's order to do something within 30 days, then you better get a receipt. You better somehow, and listen, you know what I've done in other cases too, if I can't figure out how to actually print it so that it stays where it is, I'll take a picture of the screen with my iPhone as well to show, well, it was done, it showed it done, and you can see what I saw. And it's a very fair question, and it's important that you start to think about things like that in practicing law defensively, because you don't want someone down the road saying, Ray didn't file it by the Friday deadline. You did, and that's the other thing. Sometimes you've got other stuff to worry about. You do it quick, you think you've done it. I've done this in other contexts, not in cases, and then find, oh, geez, I didn't buy that. I know I meant to buy it, and I thought I ordered it, and it doesn't show it as ordered, whatever. And the same type of thing is, you got to slow it down. If what we used to do when we would hand file stuff, sometimes if it was that important, I'd send them over with 2 copies, and I would have them file one, and then I'd want the other one date stamped so that they actually had a hard copy showing we were there and we filed it. And you do want to think a little bit about that with the electronic stuff, because things do get lost, things get filed, or things they're filed, but God knows where they end up because they're not in the right place. So I don't know, I don't think there's any particular rules for computer screw-ups, but other than you want to make sure that you're able to prove you did what you were supposed to do, because there's no doubt, and especially the other part, there's no doubt that it happens, and there's no doubt even the other part is, I don't have the same technological skills that many of you probably have, but I'll get Dan or Mick or even Amy to say, okay, is this right? Did we get this done right? Or if I can't figure out how to upload something to get it there, I'll call on Dan or Mick to make sure that we've got it in whatever right format, because sometimes it's a format, they want it in a certain format, and I have no idea what that means. And I can't imagine a lot of lawyers do know what it means, but they better have someone who's capable of being able to understand what that means. But that's why we all need some, even more than a basic understanding of some of these filing methods and computer programs and the like. There's in the First Circuit, there is an online tutorial for filing, and it'll take you through it and have you work through it before you are eligible to file. It's pretty simple, but it is helpful to really see it and sort of engage with it to have a better handle on it. But also making sure that the things are where they're supposed to be. I should have talked about, and I'll just mention quick, this 209A. I think you're all familiar with domestic relations and abuse prevention orders. And it doesn't require a domestic relations action, doesn't require anything more than someone being in fear of their safety. And we have a couple different ones where what we see is that individuals can go in to the district court or the probate court to obtain an order if they feel that their safety is at risk. And they're very serious matters. Violation of these orders can carry with it the incarceration for up to 2.5 years. And so you want to think about this. And we see it We see it a lot, and it's not always just limited to, it's a lot of, sometimes it's dating, people were dating and there's issues. Sometimes, and I don't think it's the 209, I can't remember what the statutory reference is, but neighbors sometimes have these problems as well that have to be addressed. But these types of restraining orders do not require any other type of complaint like a civil restraining order normally would, because these are concerned about safety of the individual, and the individual is arguing that their safety now is at risk, and they feel that there are threats of injury or stalking or harassment from these other people. So it's a statutory remedy that you should be aware of. And if you're defending it, you have to be very careful that your client understands the risk of it, because it is up to the court to vacate the order and change it. A lot of times we'll see violations of these orders because the defendant will say, well, she said it was okay, or he said it was okay for us to come and meet and talk. And the answer is, if there's a restraining order out, that's a violation of it unless it's modified. So be careful what you advise your clients to do, but what you need to advise them to do is it carries such serious ramifications that even if they want to vacate it, then that's a matter for you to be able to deal with and addressing with the court to actually vacate the issuance of that restraining order, because otherwise your client could end up in jail. Let's talk about Burke versus Revo, which is an interesting case. You've heard in the past the expression suits for wrongful death of a child, and we've talked about that a little bit in Civ Pro, where what we're trying to do when we have brought a suit for wrongful death of a child is to compensate the parents or the child's estate for the loss of that child, and to collect damages for their loss of life and loss of companionship and like. And it's hard to think about the damages in that context because the likelihood is the child never worked, the child never went to high school or college or really had any type of work that paid any money. So we've got to create a world that didn't exist and might not have existed for many years in order to show what the child's life was worth. But we do it all the time, creating damage models for wrongful death. But Burke versus Revo is an interesting twist on that, because what this is a suit for wrongful birth of a child. And so they're suing the doctor for medical malpractice and breach of contract, and they want the child rearing expenses and future damages from the doctor, who they're accusing violated various tort and contract laws for the birth of their normal and healthy child, but unwanted as a result of a sterilization procedure, which the mother sought for economic reasons. It just could not financially choose to support yet another child, because they're pretty expensive. And now the parents want the cost of rearing that child to adulthood. And so we've got a relatively novel suit, or was at the time, for the wrongful birth of a child. So I guess that's the first question, is philosophically, should you be allowed to sue for the wrongful birth of a healthy child? Because, well, two things in this regard. See, how would you like to be that child? Right? Mom and dad didn't want you so much, they sued when you were born. I mean, there's some policy issues here, aren't there?
The surgery
Well,
Isn't that like not like the cost of doing business, but don't you run that risk when you have someone's tubes or like go sterile? Like, they didn't promise you that it was foolproof. It's just like any form of contraceptive is not foolproof.
but he did here. And I agree with you. Normally, especially these days, that disclosure form would say, just what Marissa just said, nothing is foolproof. So if you don't want to have kids, you better use a belt and suspenders approach here, or better yet, just don't have sex for the rest of your life, because things can happen. But this is not what he said here, right? He guaranteed them that there'd be no more children. So we can get past the question of liability, because I agree with her. If you've ever signed any of these full disclosure forms, anything could happen, and that's what they're telling. It's almost silly now, because why should I bother reading it? As a lawyer, I know what it says. It says you could kill me on this operating table, and that could just happen. No, really, right? Because they have to disclose all the risks. But so now what they disclose is so many risks that it's not really realistic about what those chances are. It just tells you the worst possible case, which we know, and I need the surgery anyway, so I'm going to sign it. But so here, that disclosure today would say, and because the lawyers have consulted, and would say, no, it's going to say there's nothing foolproof about it. Outcomes are expected only. Things can happen biologically that shouldn't, but they do. But here, what we've got is a situation where we can skip right to the next stage, because this doctor somehow did guarantee them that they would never have to worry about having children again. And the case was tried on a statement of agreed facts. And the facts with respect to the child was born, this is the child's physical condition, this is what the parents are looking for. They've left out, it says, they don't really resolve the issue of liability, but the parents' argument is that the doctor promised that this wouldn't be the case. But we can put liability to the side, but my question is, as a philosophical matter, as a moral matter, should parents be allowed to sue for the wrongful birth of a healthy child? Or do you have moral issues with respect to that, or philosophical issues?
Well, the parents in this case were indigent or close to it.
Well, were they?
Well, not really. They had a bunch of kids, but I mean, in a different situation, if somebody was indigent and then they went in for a procedure to stop them from having further children, come out pregnant, who's going to take care of that kid? They can't even afford food for themselves. How are they going to afford?
Well, and the court does make a difference about if you're not having a child for financial considerations, right? But I'm not sure they're saying that these folks were poor. I have 3 kids, and they were very expensive. The 4th kid would have been, no, really, right? The 4th kid would have been just as expensive as the first 3, probably even more, right? So at some point you stop and say, you know what, this is enough for us. And so it's not that you don't have money, but you choose, because of the whatever your status is, you choose not to have any more kids. Some people are choosing, let me ask you that then. Some people choose not to have kids because they're concerned about the genetic testing and the physical issues our first child or second child had. We don't think we can take that. We can't do it again. We don't want to have any more children. What if it's that? Okay, it's not a financial consideration. We don't want to have any more children because our last child had some medical issues and we can't deal with that again. It almost broke up our marriage. It caused all sorts of problems. We don't want to have any more children because we don't have the resources here to take care of a sick child. Well, you know what? Lo and behold, they don't have a sick child. They have a healthy child. So now they don't have a suit because theirs were for non-financial reasons. They were concerned about the genetic issue. As it turns out, that issue wasn't the case. Lo and behold, you've got a healthy child. You have no damage claim?
They were promised a result and it didn't happen. Why not?
Well, but so even when does it matter why they don't want to have a child? Because here, these folks said, and it says early on, for financial reasons, economic or financial considerations, we choose not to have a child. We think they're too damn expensive, and they are, right? So that's why these people said they didn't want to have it. What about another couple who says, no, we don't want to have it because we're afraid that the child could be born with genetic defects and require constant medical attention and emotional investment that we just can't put up. We can't do. But then the child's born healthy.
I don't think the issue of murder, as a matter of personal liberty, I don't think it has to come into the question, because then you are trying to infringe on individual liberty and then our own choices.
But what's your damage?
Yeah, the damage is a justice for the child that is supposedly dead. Because if the child were reasonably alive, you understand? I mean.
Well, but that's what I'm saying. And the court's making a distinction. What if it's a healthy child? You said you have no damages. If it's not for economic reasons, you have no damages if it's a healthy child. If you're saying we don't want to have an unhealthy child, we need sterilization. But as it turns out, you have a healthy child, no case. You should
What
say
about-
thank you.
What about the womb that carried this baby, this healthy child and all that? Doesn't it take the woman through a particular labor system? I mean, I'm looking at it that, even though we're not conclusively saying that there's a damage, but of course, what about the process leading to gestation and
But
then-
you've now you didn't think it was possible to have a healthy child. You have a healthy child. My mother, God bless her, because she would say her children were gifts from God. That's where some of the attitude comes from, okay? But no, she really, that's the way she thought. So that's, I guess, because you guys have sort of blown past this sort of the moral issue about you're putting a dollar value on this human life who is now into the world.
Well, I think the parents' reasoning is kind of moot. It's more so what the doctor's responsibility is. A reasonable, prudent parent would go to a doctor who's a medical professional, and if a doctor's gonna say, I guarantee this, any reasonable person in their right mind will say, okay, doctor, if you can guarantee this, I'm gonna go with you. So I think the issue is really around what the doctor said, more as opposed to what the parents wanted.
Well, but doesn't the court make a distinction between what the intent of the parents was here? Right? And they are making a distinction as to, it depends on the reasons. So first of all, none of you are troubled by the notion that we're going to put a value on an unwanted, healthy human life.
trouble. I think on the basis
But
of-
you got past that pretty quickly.
Well, I mean, but the truth, on the basis of morality, I think the parents, I will go against the parents on this, because,
So we're in.
yeah, I am.
And so you're all in. No one's questions that this is kind of heavy baggage for
He's gonna
the.
live a better
I
life
think
with all
it's
this money.
wrong.
He'll have a better life with all his money. And someday he's in law school reading this case and says, wait a minute, Revo. No, so no one, that's, we're all good with that.
I think it opens up the floodgates for like a bigger issue, because like that means that's to say, okay, like a lot of people use forms of contraception because that isn't tying someone's tubes or going sterile because they don't want children for X, Y, and Z reason.
Right.
So what are we gonna do, sue every condom factory and every, contraceptive manufacturer? Like, it's just not.
Oh, so you don't want, for policy reasons, you would say, well, the argument you made originally, nothing is foolproof other than abstinence. Recognize that and take the risk that comes from there.
But at what point do we hold the doctor responsible? Doctors just can't be talking willy-nilly now. They can't say.
Well, I'm with you, and that's the problem here, is the doctor made certain promises, but let's say a contraceptive makes promises. You will not get pregnant for the next 5 years if you're on this device or pill or whatever it is. But you do. Well, would they be liable then? Assuming that's the case. Let's, you guys have all agreed, the doctor, assuming that promise was made, the doctor is responsible for for the cost of raising this healthy child. Soup to nuts?
Reasonable costs.
Well, okay, but let's talk about reasonable cost, because this is going to get expensive, isn't it? Right? So So, all those diapers? I mean, right, we're talking about all of it. Baby clothes, diapers, whatever, food, whatever it takes. Is the mother entitled, I was just gonna say, is the mother entitled to compensation for the 9 months she was pregnant? Yes? Is that what you're saying? Yes? And what about, and then for feeding the child and changing the diapers, the cost of daily care is on him too, or her? Is that what you're saying? Is it the cost to raise that child from birth through, and we'll figure out what the end date is here. There is an end at some point, isn't there? Ray?
I think the damages will be up to the point where you get out in the infancy stages. My main reason to say that is because there's a such thing as abortion. So the moment you knew that you were pregnant, I believe you had, 18 weeks or something like that to actually go forth with an
I
abortion.
think you got like 24, no?
Or something like that.
Okay.
I'm not precisely sure. But my point is that
Well, let me ask.
at some point you could have actually went and aborted the mission.
Yeah, what about Ray's point? You have an obligation generally in contract law to mitigate your damages. Okay, you don't want to be pregnant, have an abortion. So why should I take you anywhere beyond six months or whatever it is, whatever that period is? Why, if you choose to go forward nonetheless, why is that on me to raise this child financially?
I'm religious.
Oh, you're religious and you believe in the value of human life, right? But someone's going to pay to raise this human life, and it ain't me. No. But I think that would be the argument, right? Is that it's for religious reasons, or even personal reasons. I would think even if it's not religious, well, I didn't want to have a child, but now there's a child inside me, and okay, let me ask, and I can't abort it. Okay, give it up. Right? We just read a whole bunch of cases where people are paying people for their genetic material and then paying a surrogate. There's people that want these babies. So give it up. Again, you could mitigate your damages. You choose not to. Why is that on me, poor doctor, than you who have decided A, not to abort, and B, not to give that child up? Or is that just easy to say in a classroom? Okay, so now I'm supposed to give up my child who was conceived as a result of your negligence or breach of contract, and I'm supposed to know that my fourth kid is out there somewhere in the world.
I am thinking that on the breach of contract, you are right. It's now on the doctor. But when it comes to the issue of negligence, maybe we can possibly think of holding it up.
Okay, well, it doesn't matter how they win. They don't care whether it's toward a contract. Because we got to figure out the damages. Why don't they have an obligation to mitigate their damages as one would normally do in a contract situation, at least? Go ahead.
Well, maybe in this situation, they should be compensated up until the time of childbirth, when the child is actually reared. So the whole time, the whole 9 months.
But they get a lot more expensive after the birth.
That's true, but at that point, she has the decision that she can actually give it up for adoption or give it to someone else.
Would you make someone do that so they have to carry it? They would carry a child to term and then have to give up their own child, and their other siblings get to live happily in the house with mom and dad.
That's a choice.
Is it a choice, or is this still on the doctor? I mean, I hear you. You could mitigate your damages. Geez, now we're asking someone to make a pretty hard decision. Okay, I agree. We all want to stay away from that abortion issue. We won't make you abort the child, but if you have them, you got to give them up.
I'm fine with that because.
You're fine with that, making someone give up their child?
Yeah, I am, because the premise of why you didn't want a kid was financial reasons.
So
That's
just give them up to someone who both emotionally and financially has the wherewithal to support them. And so you just have to live the rest of your 30, 40, or 50 years of your life knowing you've got a kid out there somewhere who you decided to give away.
I'm sure they'll come find you.
That's solution. I'm sure they'll come find you. Okay, well, if we either force them to abort the child or give it up, then the rest of the discussion we don't need to have, because but the case focuses on the more of this as well. If the parents have kept the child, so what are the damages? And are the damages everything? It's the diapers, it's the clothes, it's the $200 sneakers when they're older. Do they get to go to summer camp? Private school? What if the other kids in the family went to private school? Private school?
Kind of reminds me of Civ Pro, the whole we owe them an arm. Do we get them the best arm in the world, or we just give them like a shitty little arm?
Yeah, right. So he can be the third or fourth kid in the family, but he doesn't get new clothes like the others, and he doesn't get to go to summer camp like the others. Why shouldn't the doctor pay? If that is the quality of life the others had, so that we're not giving them the Cadillac, but we're giving them what they would have otherwise received, is that all on the doctor? Because we're talking cha-ching, cha-ching, cha-ching here. And we haven't even gotten to private high school or college yet, right? And by the way, so when would it end? So does it end at 18, or does it, like child support, if the kid is still in school, then it would go through 22, well, if they're in college. And I'm the doctor, I'm paying for college. I'm paying for college for someone else's kid. No, you're shaking your head no? You're the one that said that they could sue.
Right,
But give it up.
They should have the age of majority, for sure.
Well, why is it 18 if the other kids went to college, and the parents helped those kids? They would help this child, wouldn't they? Why shouldn't we say, well, we'd bring you to college, but Dr. Mark doesn't want to pay for your college. Well, but you're my mother and father. Can't you help me like you help my brothers and sister?
I say up to the age, I say up to pre-K. Hope the doctor pays for the damages up to pre-K, and that's that.
But how is that, if we're going to say that the doctor caused these damages, but for the doctor's violation of law, that these would not be expenses the parents incurred, then shouldn't it go well through pre-K, through grammar school, through high school, and perhaps even college? I mean, those are the damages that these parents have suffered. That's the financial damages. If, as the court says, if it was for economic reasons, and you've got to take a careful look at the case. The case does make a distinction between economic reasons. If you're not having children for economic reasons, because of, obviously, the cost, the financial considerations, and you have a healthy child, then we'll compensate you. If you have a sick child, then we'll compensate you even more, because that child needs special medical attention and has additional financial needs that the doctor will now have to pay for. But they also do say that if it's not for economic reasons, it's because, well, you had one child and the genetic testing was sketchy, or that child has some issues, you don't want to deal with those for a second child, but then it turns out that you have a healthy child, well, then you've got to give from God, say thank God, and move on. If it's not for economic reasons, then you don't have a claim at all. That's what the majority says. But if you have a claim, then how far up the line does it go here? Because they're talking about whatever those, it says damages include, well, here, look at page 767. Parents may recover the economic expense of rearing the child. Damages include physical pain and suffering and mental anguish of the mother, husband's loss of consortium and medical expenses of pregnancy, but not child rearing expenses. They take Ray's point, but this was Wilbur versus Care from Arkansas. But these folks here, in our case, they want the cost of rearing and educating the child. So this is going to break a little bit of new ground. And even New Hampshire, if you look down that page on 767, 182 in the book, it says, New Hampshire won't give you child rearing costs either. They'll give you the mother's lost earnings, husband's loss of consortium, mother's pain and suffering, obviously the cost of a new sterilization procedure, but you're not getting the child rearing expenses. Here, though, they want all of their damages. Look at the bottom of 768. The cost would obviously include a new sterilization procedure, wife's lost earning capacity while she's pregnant and giving birth and the like, medical expenses of the delivery, care following the birth, cost of care for the other children while the wife was incapacitated, the cost of the second sterilization, which we've already said, we would add in the wife's pain and suffering as well. But they want more than that. Look at top of page 769. Principal issue is whether the plaintiffs are entitled, if they establish liability, to the cost of raising their child. Under normal tort and contract principles, that cost is both a reasonably foreseeable and natural and probable consequence of the wrongs that the plaintiffs allege. The question is whether there is any public policy consideration to which we should give effect to limit traditional tort and contract damages. We conclude that there is none as to parents who have elected sterilization for economic reasons. So if that's the reason, you just hit the lottery, because these kids are expensive. Now, let me ask you that. So would you counsel your clients when they came into your office that if this is for economic reasons, you have a whopper of a claim, but if you got sterilization because for other reasons, concerns about genetic issues or raising an unhealthy child, then you've got no claim if that child is healthy? Would you explain that to them? Because they might shape their testimony. Because we're talking potentially 7 figures in a case, right? I don't know what it used to be. They used to have figures of the cost of raising a child to a certain age. I don't know. It used to be a lot more modest, but I can't imagine must be close to 7 figures these days, right? But here they're making a difference depending on why you're not having the child. So let me ask you this.
Wouldn't it be unethical to kind of
Say what?
Wouldn't it be unethical to kind of coach your client?
Oh, it absolutely would, but you've got to tell, yes, but you do have to explain to them the difference. But that's, I guess, what I'm asking is, if you explain the difference to them, don't you think it's likely they're going to shape their reasons when you explain that as well? I mean, they're mad at the doctor. They didn't want to have a child. They now have one who's healthy. Hopefully they're good parents and accepting of that. But at the same point, they're looking for recovery, and there's no recovery if it's for anything other than economic reasons. And I don't think, and just to come back to Jesus' first point, that doesn't mean indigent. What that means is we like the quality of life we have. We don't want to spend whatever money we have, we're going to spend on the 3 kids we have. We don't want to have another child for various reasons, one of which is the cost of those kids. Come back, tell me on page 771, because it says, a substantial number of jurisdictions have allowed recovery of the cost of rearing a normal child to adulthood. That's a big number, right? That's a really big number. Offset, however, by the benefits that the parents receive in having a normal, healthy child. Okay. That's my question. So what are they worth? What's that offset, right? So it's not all a net negative. Yes, children are expensive. Many people make the choice to have children, despite their expense. So how much of a credit does the doctor get? Because it says, okay, we can tally up the expenses. That's pretty easy. What's the financial benefit? Like, no one greets me at home like my little dog, right? But it's nice to have kids. So there is a net benefit, isn't there? I got to feed the dog and take care of him, take him to the vet, all the rest. But it is a benefit. Well, same thing with kids, isn't it? But how do we put a monetary value on that? Because that's what the doctor's saying is, okay, you got the kid, you chose to keep it, you could have aborted it, you could have given him up for adoption. For whatever reason, you felt that you wanted to keep the child, and you were gonna make me pay to raise it. That's maybe one of the reasons I decided to keep it. But I get a credit, don't I? And so what is a child worth? To what extent do they improve? What's that face for you? Jeeves is shaking his head like, not much. No, but
just the joy of having a kid.
yeah, isn't that what it is? A companionship, someone to play ball with, to go fishing with. I mean, many people choose to have children. They must feel that there's some benefit to their life because of it, or why do they do it otherwise? No? Why did... I assume it's not all a net negative, or many people would be a population in significant decline, wouldn't we? So what is how are you going to monetize the benefit? $100 a day? $50 a day? Jesus, you must have been a real joy to your parents. Why don't maybe we should call Dad and ask him. But it's not a net negative. There's got to be, what's the number and how do you value it? How do you value the joy you bring into your parents' lives?
Well, the case says that the joy that the parents feel outweighs any economic loss that they may suffer.
So
that's what the case is. But
well, wait a minute. I'm not sure the case says that. I think the dissent may say that.
Well,
We're going to talk about the dissent from a different standpoint as well.
It says on my page, it starts with...
What page?
After that paragraph you just read, the principle, right under that paragraph, it says many jurisdictions often relied, and it's the second...
Oh, yeah, many say it's an offset. Okay, but that's like New Hampshire, that's like Arkansas, which says, okay, up until the child is born, you've got expenses, but you're not getting the normal child rearing expenses because those are offset. We see the child rearing expenses versus the joy they bring you, that's a wash. But here Massachusetts is deciding, the majority is deciding, we've got to set a different rule now. But so yeah, we're going to say you get the cost of rearing that child to adulthood. However, we're going to give the doctor a credit for you now having that child in your life. So how do we value that portion of it? Because that's what they're telling us we have to do. So what is it? How do you value that? You had no trouble valuing all those expenses.
You skip the first couple of years when they're just crying babies. That's not joyful.
No. You can't, well, sometimes it is. My son just had a little baby girl. She cries a lot, but she's really sweet too. And because if you're going to cut those years out, what are you going to do with the teenage years? 11 through 16 can really be miserable. When you have the car keys, you have some control back again. But so what's the value here? But because they say we get a credit, and then, okay, I want to ask you, you can think about that. They say we get a credit. I don't know how you're going to value it either. $50 a day, even $50 a day is going to be a lot of money on a yearly basis, right? $50 a day, is that about what, 18,000 over the course of a year? Or is that 1,800? 365, 1865, 18. So it'll be like 185, say 0, 0. Yeah, it's 18,000 a year, $50 a day, I think. Yeah.
Don't you do a daily cost analysis to figure out how much they spend on a daily basis?
Well, but spend you're going to get, spend them, as I understand it, the cost of rearing that child is going to be clothing, schooling, food, movies, sneakers, right? The cost of rearing is going to be everything that goes into it. And if the other kids, and it doesn't, you're not getting to go to the best summer camp. If your brothers and sisters didn't, you're going to the Y too. But you're going to the Y. And if your brothers and sisters went to state college, that's where you're going.
Maybe the doctor gets $1 million credit.
Well, how are you coming up with $1 million?
Well, if it's 10 million, 7 figures. roughly.
Where did you get to 10 million?
Well, you said that roughly it's 7-figure judgment, right?
I think so, yeah.
So if it's, let's say.
Well, that's what I'm thinking. Someone Google, what's the average cost of rearing a child to rearing a child these days? You'll get a number, but go ahead. So I'm saying, it used to be, the number used to be, actually, I thought it was low before when we've looked at this, but let's say it's 750.
233,610, excluding the cost of college for a middle-income family, according to the United States Department.
See, that's what I've heard before. I just don't
But
buy
I think
that.
that's ridiculous.
I do
Because
too.
if you think about, like, I nanny, and I've nannied since I was 17 years old, and, the kids, I've nannied for middle-class families, I've nannied for upper-middle-class families. No, I see what they pay me an hour. I see what they pay me.
Well, that's why when I've heard, that's what the number was before, was like 250, and I reject that completely, because that's just not true. I mean, damn, you know, they'll go through, each of them will go through $75 worth of food a week. And forget the nanny, the childcare these days. Childcare is off the charts, right? I mean, and so let's talk about covering them with health care, summer camps. Summer camps these days, I imagine a lot of folks are spending, I can't even imagine how much summer camps for multiple children these days. So I don't agree with the number, but let's say it's 5. Let's double it and say it's 5, without the cost of college.
Maybe.
So what's the credit?
We'll give them a percentage of it, so maybe 1/10 of it.
So a tenth. So it's going to be $500,000, but I'm getting $50,000 back. That's it. I mean, you were able to put a number on all these expenses. Why can't we figure out, is there a joy figure? Is there a daily joy? Go home, you know, when the kids were little, go home and they were all there and they're looking forward to see, you know, it was almost as good as seeing Fritz. No, but you get the point. Look at the top of page 772. And this is the point I was trying to make to you. So this becomes problematic. If the parent's desire to avoid the birth of a child was founded on eugenic reasons, avoidance of feared genetic defect, or was founded on therapeutic reasons, concern for the mother's health, and if a healthy, normal baby is born, the justification for allowing recovery of the cost of rearing a normal child to maturity is far less than when, to conserve family resources, the parent sought unsuccessfully to avoid conceiving another child. They're saying that the reason has to be financial and economic, because otherwise we're not going to give you this cost of rearing the child in all likelihood, because you have a gift at this point. You have a healthy child that won't require extraordinary demands on you emotionally or financially more than they would have otherwise. I'm a little troubled even by this though, but I do recognize why we have to do it. So we're going to say that these healthy, normal children are worth significantly more than, you know, damaged children with whatever the issues are. And I get why we have to do that. But it sounds like from a policy reason that there's something wrong with that, no? So if they're not perfect, that's what really we're talking about, healthy, normal baby, because we all have issues, don't we? I mean, if you're expecting these children to be perfect, then you're going to be sadly mistaken. That's the way life is. But I do worry a little bit about that type of language. I get it, because it's obviously there's a significant and a much greater expense if child needs extraordinary medical care or even just more tutorial services in school and everything else. That's not necessarily something anyone bargains for.
What's the standard that they're using for determining healthy, and what's the range?
Normal.
of
Well,
that
what's the
period?
standard for normal?
Right. What's the
You know?
period of that range?
I
that
don't
they're
know.
Doing this assessment.
Okay, I got another question for you. You see the dissent? O'Connor, Nolan, and Lynch. Now, Lynch, he was one of the trustees of the law school for many years. Really, really nice guy. I know him well. A really, really nice man. Nolan, I was before too, and O'Connor. And so I can say this, being one. 3, Nolan had 8 kids. Seriously, true. 3 Irish Catholics. Do you think their religious views influence their dissent here, saying, hey, this is wrong. You can't be putting the value on a human life, you know, so yes? So is that appropriate, that a judge's religious views influence their legal decisions? Because I do think that's what's at risk here. Go ahead.
Everybody's views always determine their reasoning. I mean, meaning that you can have a bias towards certain kind of people, and that will come out inside your decisions. I mean, you can have a bias towards a certain kind of religion, and that also shows in your decisions. I mean, biases are there, and stereotypes are there. These are things that we just can't fight.
Really?
I mean, I just don't think I don't think we can fight
Go ahead.
it. I mean, we spent hundreds of years trying to do that.
No, I
Not necessarily fight, but we could control it if we are aware of it, if we accept that, you know. And I think the first step was just being like accepting that we have implicit biases. You just meet someone one day, you just don't like the person, not because the person has done anything, but it just happens. You know, it doesn't make you a bad person.
But I thought judges were supposed to put aside their personal preferences and their biases and try to decide things on their merits. And I'm not saying these judges didn't see it as deciding it on the basis of the law, but in a case like this, there are significant policy issues that have to be addressed, and I'm wondering to what extent they may have been influenced by their religious backgrounds here, because I do think, and especially reading the language in the case, that there is some religious influence and connotation to it. You know, this is not a run-of-the-mill medical malpractice case involving, as it does, the creation of a new human life.
Yeah, I think one of the reasons that their view actually align more of a religious one to me is, if you look at a case in totality, it's more of morality issues.
In this one.
Yeah.
Well, and that's what, but let me ask you that, because, and I agree with that in this, especially in this one. This is not purely law. This is a question of morality, and as they would see it, and I do think, I always wish Justice Lynch had died before we started using this in class, because I would have asked him. And because I do think the case is kind of unique to me, because when I look at the 3 dissenters, I know their backgrounds, and they clearly are people that I went to Justice Lynch's funeral. I mean, he was in a church with the mass and the full shebang. And I know Nolan and I know O'Connor. I do think in some of this, whether they recognize it or not, their influence is from their upbringing and the rest of it. But I think in part that's what they're asking the court to do in this case. The end of that next paragraph says, however, in my view, it would be equally intolerable for a judge or jury to engage in any inquiry concerning the probable value of a child to his or her parents. I mean, they have, to me, reading the dissent, they have all sorts of problems with trying to look at the economic value of this, of what my mother had said was God's gift to her. That now we're talking, and what's kind of odd about it though is we do it all the time for wrongful death, right? It's not unique that we have to place financial values on human lives and the human condition as to what extent it has been diminished as a result of certain people's activities. What these 3 are worried about is this whole idea that somehow it just becomes a financial consideration when there's something much more at work here otherwise. Jeeves said, we actually, and you guys both said that it's almost something we have to expect, that people are going to be, the judges are going to be influenced by their upbringing and their background. If that's the case, what does that mean for us as advocates? I mean, okay, let's recognize it. Okay, we're all supposed to be treated equally. You're supposed to put all those things you prefer and the biases you have in the background. But as people, we know that that's not really possible. You're still influenced by who you are and where you came from, in some ways. So is that something we can use as advocates?
Good, to your advantage.
And would it be appropriate too? Or is this where we're now crossing that moral line where we're going to be trouble with whoever you believe judges you at the end of your days if you do?
No, I think that's perfectly fine. I think that's what we do as lawyers. You know, when we find out who's presiding on a case, the first thing we do is go look up every ruling that judge potentially did, just to make sure, okay, well, you know, he's a tough guy, so I'm gonna make sure I have to, you know, do these. Or he, you know, he loves children and I represent a child, so let me do my best to make my child look great in front of this judge. So I don't think there's nothing wrong with that.
Nothing wrong with it. So just talking about winning. So now we'll play on your bias and your religious preferences and your religious background to give you, no, you're out?
There is a lot wrong with it. I think from a legal standpoint, if you want to talk about strategy, fair enough. But if you want to put yourself in that empathic situation, with learning ethics and all that, and if you have to balance that with our human setup and then the society as a whole, it doesn't serve the larger good. I don't think so. I think that in the case of this judge, for instance, I mean, the three who dissented, it's not supposed to be. I mean, you can, you know, infuse your religious values and ideals into public policy and all that, and even a legal rule.
Well, but you're going to play the public policy angles that may more strongly resonate with the likely background of these folks.
I do not argue that.
But you're saying that's okay, aren't you?
Yeah, I do. But what I'm saying, for instance, just yesterday, I mean, someone called me from Ghana where my friends are practicing, and a judge sentenced someone to prison for almost 20 years for just inhaling some kind of genetic marijuana. And I was like, how will you? Because the judge was a Catholic, you know, and to him, it's against his own background and his indoctrination and his upbringing. I don't think, fairly enough, that is something that a judge should do. You see what I mean? So I'm just arguing that.
I don't disagree that it shouldn't.
I'm just saying that on a micro level, if everybody should start to align himself or herself in that way, that we know biases exist, and whatever we do, we can't just undo them because inadvertently it comes into our decisions. Then on a bigger scale, what are we creating? You know.
Well, but aren't we being realistic though? Because that is what I'm wondering is if we go in with sort of rose-colored glasses and think that this doesn't exist out there, let's be real. You know, I've told you before. Well, I didn't have many of you for evidence, but when we have evidence, you know, we're going to court at a trial. I'm going to dress him up and I'm going to shine him up and I'm going to put him on a tie, and I may have bought the tie, okay, and that may be the only tie they'll ever wear. But we do play that, don't we? We try to put forward the best case for the audience that we've got. I guess I'm asking here, when you look at this, it's almost something we might not have thought about, but that background is like a background like this runs deep. I mean, you know, some of these guys might have started in grammar school, going to religious school and the like. So it's not necessarily something we could say as a judge, or that we're just going to put all that aside. But I read this decision and see that influence there all over it. Let me ask you a related question then, before we leave this. Shouldn't we expect it though? A lot of our laws are really representative of some of the church's position or the religious organization's positions at various times, right? Kraft is now charged with soliciting a prostitution, right? I mean, that's as much what we would have said was as a result of the religious influence as well as certainly the law, right? We used to not be able to buy alcohol on Sundays here because that was the day of worship. You shouldn't be doing that. There's still rules about not having, being able to have a liquor store within certain distances of a church. And I think that's carried over even to the new marijuana laws with respect to how close they can be to, certainly to schools, and I believe religious organizations as well. and so this is what I'm gonna leave you with the question, is, so haven't our laws, haven't our cases, haven't even the decisions like this historically been influenced by religious organizations and religious views? So maybe this shouldn't be such a big surprise. But so that means then it's even more so that we've got to think about how to deal with some of this. Because I would like, to think it's only on the law, but the law has certainly been influenced by religious views. And when I read a case like this, and I like all three of these, and I would really love to ask the question is, do they believe that it was influenced by their religious upbringing and teachings over the years? Because I read it and see, I think it was. But I also think, though, it's a tough call anyway.
I don't even think they would even recognize.
I know, that's what I'm wondering. That's what I'm curious about.
Because if because I went to private school too when I was younger in Catholic school. You were actually just being trained, and your mind isn't thinking
Yeah, I
about
agree.
that. And as you get older, that's embedded in you. Just it's kind of like racism. I hate to bring up the topic. Racism is something that is taught to people. So as they get older, they think their conduct is normal, but it's really not.
Right.
Well, I guess in our eyes, but in their head, it's normal. So I think the best way to honestly handle anything like this, profile who you're about to go in front of. Sadly but true, I wish my colleague to the right, I wish he was right as far as bias doesn't exist and we should treat everything fairly. But we live in a society where it's just not practical.
I know. I think so too. And that's, as an advocate, we have to recognize it.
Right.
And so, yeah, I'm gonna use religious references if I'm arguing this case with these judges. We'll talk next time.
Like I use David the Goliath all the time.
Huh?
I mean,